Have you ever had an idea and wondered, can I patent this? Maybe you invented a new gadget. Maybe you designed a unique product. Maybe you developed a better way to do something. But here's the thing, not everything can be patented. The United States Patent and Trademark Office has very specific rules about what qualifies for patent protection. And if you don't understand these rules, you could waste thousands of dollars filing for a patent that will never be granted. So today, we're breaking it all down. What can you patent? What can't you patent? What are the requirements? And how does a patent differ from a trademark or copyright? By the end of this video, you'll know exactly what's patentable and what isn't. Let's dive in. First, let's define what a patent actually is. A patent is a legal agreement between you and the United States government. Here's how it works. You reveal to the government exactly how your invention works. You provide detailed descriptions, drawings, formulas, processes, everything someone would need to recreate your invention. In exchange, the government gives you exclusive rights to your invention for a limited time. For most patents, that's 20 years from the date you file your application. During those 20 years, you have the right to exclude others from making, using, selling, or importing your invention without your permission. Notice I said exclude others, not make it yourself. A patent doesn't give you the right to make your invention. It gives you the right to stop others from making it. This is important. For example, you might patent an improvement to an existing technology. But if that existing technology is also patented by someone else, you can't make your invention without their permission, even though you have a patent on it. After 20 years, your patent expires. Once it expires, your invention enters the public domain. Anyone can make it. Anyone can sell it. The knowledge belongs to everyone. That's the trade-off. Temporary exclusivity in exchange for public disclosure. Now here's what most people don't know. Not everything can be patented. The Patent Office has strict requirements, and there are 3 different types of patents, each with different rules. Let's start with the types. The United States Patent and Trademark Office grants 3 types of patents. Type 1, utility patents. This is what most people think of when they hear patent. Utility patents protect how something works. They cover processes, methods or techniques for doing something, machines, devices with moving parts, manufacturers, objects or products without moving parts, compositions of matter, chemical compounds, mixtures, formulas. Examples: a new pharmaceutical drug, a manufacturing process for making steel, a mechanical device like an engine, a software algorithm implemented in a computer system. Utility patents last 20 years from the filing date. Type 2, design patents. Design patents protect how something looks. They cover the ornamental appearance of a product, its shape, configuration, or surface ornamentation. They do not protect how the product functions, only how it looks. Examples: the shape of the Coca-Cola bottle, the design of an iPhone, the appearance of a piece of furniture, a unique pattern on fabric. Design patents last 15 years from the date they're granted, not filed. Type 3, plant patents. Plant patents protect new varieties of plants that have been asexually reproduced. This means plants reproduced without seeds, through cuttings, grafting, tissue culture, or other methods. You cannot patent plants found in the wild. Tuber-propagated plants like potatoes. You can patent a new hybrid rose variety, a new fruit tree cultivar, a unique ornamental plant you developed. Plant patents last 20 years from the filing date. Now that you know the 3 types, let's focus on utility patents, because that's what most inventors are pursuing. If you're learning something new, hit that like button and subscribe. We're about to break down exactly what you need to get a utility patent, and it's more specific than you think. To get a utility patent, your invention must meet 4 requirements. All 4. Not 3, not 2, all 4. If your invention fails even one of these tests, it cannot be patented. Requirement number 1. It must be able to be used. Your invention has to actually work. You can't patent a theory. You can't patent an idea that only exists on paper. It must be functional. It must serve a real purpose. For example, you cannot patent a perpetual motion machine because physics says it's impossible. You cannot patent a teleportation device because it doesn't actually work. But you can patent a new type of battery that stores energy more efficiently, a medical device that monitors heart rate in a new way, A manufacturing process that reduces waste. Bottom line, if it doesn't work, you can't patent it. Requirement number 2, you must provide a clear description. Your patent application must explain how to make and use your invention. The description must be detailed enough that someone skilled in the field could recreate your invention just by reading your patent. This is called the enablement requirement. You don't have to build a working prototype, but you do have to describe it clearly. For example, if you're patenting a new chemical compound, you must explain the chemical formula, how to synthesize it, what it does, how to use it. If your description is vague or incomplete, your patent will be rejected. Requirement number 3, it must be novel. Novel means new. Your invention must be something that has never been done before. If someone already invented it, you can't patent it. If it's been publicly disclosed anywhere in the world, you can't patent it. This is called the novelty requirement. For example, you can't patent a regular wooden chair. Chairs exist. But you could patent a chair with a completely new folding mechanism that nobody has ever designed. The Patent Office searches existing patents, published research, and public records to determine if your invention is truly new. If they find something identical, your application will be rejected. Requirement number 4, it must be non-obvious. This is the trickiest requirement. Non-obvious means that someone skilled in your field wouldn't think, "Oh yeah, that's obvious." You can't just take two existing things, combine them in a predictable way, and call it an invention. For example, you can't patent a pencil with an eraser if pencils and erasers already exist and it's obvious to combine them. But you could patent a new type of eraser material that works better than anything before. The test is, would a person with ordinary skill in the field find this combination or improvement obvious? If yes, it's not patentable. If no, it might be. All 4 requirements: novel, non-obvious, useful, able to be used. If your invention meets all 4, you're ready for the next step, determining if it fits into a patentable category. The Patent Office recognizes 4 categories of inventions that can be patented. Category 1, processes. A process is a series of steps that produces a result. Examples: a method for refining oil, a technique for manufacturing plastic, a process for treating wastewater, a method for encrypting data. If you invent a new way to do something that's novel, non-obvious, and useful, you can patent the process. Category 2, machines. A machine is a device with moving parts that performs a function. Examples: an engine, a robotic arm, a printing press, a medical scanning device. If you invent a machine that's new, non-obvious, and useful, you can patent it. Category 3, manufactures. Manufactures are physical objects without moving parts. Examples: a light bulb, a shoe sole, a bottle design, a tool handle. If you create a manufactured object with a new design or structure, you can patent it. Category 4, compositions of matter. This covers any new chemical composition or mixture. Examples: a pharmaceutical drug, a new steel alloy, an adhesive formula, a cosmetic cream. If you create a new substance that didn't exist before, you can patent it. There's also a 5th category, design patents, which we covered earlier. Design patents protect how something looks, not how it works. Now here's what gets confusing. Just because something fits into one of these categories doesn't mean it's automatically patentable. There are things you absolutely cannot patent, no matter how clever they are. Here's where it gets interesting. There are specific things the Patent Office will never grant a patent for. You cannot patent laws of nature. You can't patent gravity. You can't patent E=mc². You can't patent photosynthesis. These are natural phenomena. You didn't create them, you just discovered them. But you can patent an application of a natural law. You can't patent electricity, but you can patent a light bulb that uses electricity in a new way. You cannot patent abstract ideas. You can't patent a mathematical formula by itself, a business method without a specific implementation, an algorithm on its own. This is why you'll never see a patent for the idea of online shopping or the concept of social media. But you can patent a specific implementation of an idea. You can't patent a method for ranking search results, but Google patented their specific PageRank algorithm as implemented in a computer system. You cannot patent naturally occurring things. You can't patent a plant that grows in the wild, a mineral found in the ground, human genes as they exist in nature. But you can patent genetically modified organisms, synthetic versions of natural substances, new plant varieties you bred in a lab. You can't patent a wild strawberry, but you can patent a new hybrid. You cannot patent artistic works. You can't patent a song, a painting, a book, a movie. Those are protected by copyright, not patents. Copyright is handled by the Library of Congress, not the Patent Office. But you can patent the tool or method used to create art. You can't patent the photograph, but you can patent a new type of camera. You cannot patent brand names or logos. You can't patent a company name, a slogan, a logo. Those are protected by trademarks, not patents. Trademarks are also handled by the Patent Office, but they're completely different from patents. Let me clarify the difference real quick. This confuses a lot of people, so let's clear it up. Patents protect inventions, how things work or how they look. Duration, 15 to 20 years. Examples, a new engine, a pharmaceutical drug, a manufacturing process. Trademarks protect brand identifiers, names, logos, slogans. Duration, forever, as long as you maintain them. Examples, Nike swoosh, just do it, Coca-Cola bottle shape. Copyrights protect creative works, artistic expression. Duration, life of author plus 70 years. Examples, songs, books, movies, paintings. All three are types of intellectual property, but they protect different things. You can't patent a logo, that's a trademark. You can't patent a song, that's a copyright. You can't trademark an invention, that's a patent. Make sense? All right, let's bust some common myths before we wrap up. Myth number 1, you can't patent food. Wrong. You can absolutely patent food products and food processes. What you can't do is patent a naturally occurring food. You can't patent an apple, but you can patent a new food preservation process, a unique food formulation, a new apple-based product. Myth number 2, you need a working prototype to get a patent. Wrong. You don't need a physical model. You just need to describe your invention clearly enough that someone skilled in the field could build it. Drawings and detailed descriptions are usually enough. Myth number 3, if I file a patent, my idea is protected immediately. Wrong. Patent applications can take years to process. In the United States, the average is 22 to 26 months. During that time, your invention isn't protected unless you file for a provisional patent first. Myth number 4, a patent means nobody can ever make my invention. Wrong. A patent just means nobody can make it without your permission. You can license your patent to companies, sell your patent rights, let people use it for free if you want. But if someone makes it without permission, you can sue them. So let's recap. What you can patent: processes, methods, techniques, machines, devices with moving parts, manufacturers, objects without moving parts, compositions of matter, chemicals, mixtures, designs, ornamental appearance, plants, new asexually reproduced varieties. Requirements: able to be used, it must work. Clear description, how to make and use it. Novel, new, not done before. Non-obvious, not just a predictable combination. What you cannot patent: laws of nature, abstract ideas, naturally occurring things, artistic works, those get copyrights. Brand names, logos, those get trademarks. Now you know exactly what's patentable and what isn't. If you have an invention and you're not sure if it qualifies, consult with a registered patent attorney before filing. Patents can be incredibly valuable, but only if they're filed correctly. If this video helped you understand patents, hit that like button and subscribe for more educational content. Drop a comment. What invention do you think should have been patented? Thanks for watching, and we'll see you in the next one.